Percy may keep them as part 100.
That's the next
Chair of
week.
London
Lord.
Council. Item 2,
My lord, may keep them as part 100.
Part
I'm not seeing any.
Only payload your losses ordered at 11:1.
Sir.
View of this election,
Why this thing? We have made person also still
but then you have to file a lot of
And enclosing that particular document.
subject to what is.
My lord, that we have already stated in our affidavit that he was not a member of that particular interview board in which his son and daughter appears before the interview. The marks allotted by each of the board we have annexed in the my lord our affidavit. All the marks, my lord, awarded by the my lord.
There was one common interview board. There was
No, my
one
lord,
common
three interview board. Three interview board. There are three interview boards. All the candidates were divided into three interview boards, and the petition, the son of the number 6, my lord, he appeared interview board number 1, and the petitioner also appeared in that particular interview, and the respondent number 9 appeared in another interview board, my lord. And the marks, if the lordship, on that day, my lord, earlier we annex the documents of the marks allotted to the candidate.
Which page is
In the page number 136, my lord. Our affidavit, my lord. Additional affidavit. Number 1. Paragraph 3. That the successful candidates of the written test were called for the vibability test to conduct the vibability test. 3 interview boards were constituted by the authority of Karbi Anglong Autonomous Council to assess the merit of the candidates. The interview board number was considered with Amar Gogoi, SCS Tension and Tension Congress Pensu. The petitioner, along with respondent number 8, 10, and 11, were interviewed by the interview board number 1. The respondent number 7, Sri Dhaneshwar Ingti, was not a member of the interview board number 1. The interview board number 2 was constituted with Dhaneshwar Ingti, Suenso, the respondent number 7, Sri Suenso and Sri Suenso Ingti. The respondent number 7 was the member of the interview board number 2. The petitioner and the respondent number 8 to 11 were not the candidates allotted to the interview board number 2. The interview board number 3 was considered with say so and so, so and so. And the marks, what are the marks we have stated in paragraph 4, my lord? What are the marks allotted to the candidates, my lord? And annex all the documents, my lord. Each of the interview board member evaluated the candidate separately, and each of them have awarded the marks separately. And my lord, the judgment which relied on by the petitioner, my lord, in that judgment itself, my lord, that judgment, what is the, my lord, they endorsed the view, my lord, they endorsed the view of the Rasul case, which my learned friend, my lord, argued on that date. And in that particular said, judgment state, the Supreme Court held that if the person, my lord, he withdraws from the interview, then the interview is valid, and that he was endorsed by that particular judgment. Ashok Srivastava.
So some hearing, some more hearing.
Yes, my lord.
Have it.
Hello.
Tomorrow, I don't. He's a member. But he was in that board which part of that. But default is a member or a member. A member secretary.
This case, respondent number 7 was secretary.
Yes, that's why. For a moment, my lord, for a moment, let us say that he was a member secretary. But default, he is a member secretary. Either he has to resign from that post because I'm a member secretary. I'll resign because my son and daughter is in the interview. He has to resign from that post by default. So here is also one case, similar case, where one of
So
the.
doesn't have to resign, he has to recuse
No,
from
that's
the.
why he was not there. He recused himself. That's why my lord will kindly see there is not one board. There were 3 boards which was constituted, not one board. 3 boards on record it is
So
constituted.
he was the member secretary of what?
He was a member secretary of my learned friend.
Can I clarify?
Have to
Yes,
hearing.
yes. But today's instruction,
Oh, that instruction is already there. Nothing.
a part of the
Yeah, can
record, my.
copy.
Table.
My lord, this of application 46 of the company 950. That's the position, the premise on which I prefer this. There is an application that is I preferred the DRT. The learned DRT has already issued notice on my application. And it is an admitted position now by virtue of their affidavits which they have filed saying that yes, there were 3.16 crores worth of security lying in our hands now, which has gone missing. Your the certificate debt was issued for 0.55 crores. They had securities worth in plant and machinery worth almost 28 crores at that material time, Your Lordship. In addition to the 3.16 crores worth of movable assets, which they have admitted that were lying in their hand. Between the date when the RC was issued in 2008 and the handover which they did allegedly and purportedly the OL in the Madhya Pradesh in 2010. My lords, my premise, my position is fairly simple. All I'm on is that because authority which had given to them, had they satisfied it, actually given me some money back, 0.55 crores worth of debt, because they should have liquidated at that point in time. Now,
No, wait a minute. Today, what has come up? The IA or the company?
the IA,
The prayer in the IA?
to stay the winding up,
So, the applicant is, company is under liquidation.
provisionally winding up order, provisional winding up order has been passed.
Now, under liquidation, what, payment of debt?
I was the guarantor for the principal borrower. The borrower has been bound up. In fact, the OL proceedings before the Honorable Madhya Pradesh High Court still is yet to come. There is still a plot number 4 which auction latest orders. The OL also seeks time to be advertise entire lot. My position is this, my lords, that now because the debt has not been crystallized, I mean, I'm not even sure or confident that what they're asking is actually due to them. Because of the certificate debt which was issued, the amount which was granted to them was 0.55 crore, which has been satisfied. And the learned DRT, my lords, has already issued notice on the application. My lords may have page number 218, is the orders, lordships.
So you are the guarantor.
I am the one of the corporate guarantors. My lords may have page number 118. That's the orders of the learned DRT Calcutta. DRT. The second paragraph, advocate appearing on behalf of CD number 3 submits that their interim application dated so and so has been dismissed by the orders due to of the latches of the part of the advocate on record. But another interim application filed by them on 8/21 bearing RCIA 132 of 21 is still pending adjudication. But the CHB has not filed any written opposition to the same. And my lords, this application years now. They have
This is pending where?
before the learned DRT Calcutta. And by virtue of this application, I have prayed that the entire debt stands satisfied. I do not owe them any money. In fact, they have to now give me money once there's reconciliation and rendition of accounts. And on that premise, Your Lordship, praying that this proceeding may be stayed tiny time till the time this application is dismissed.
And what is the stage of the winding up process?
It's still, the company has been wound up, but the assets of the principal borrower still is yet to be disposed of by the.
We can consider the order you're seeking, but for that, the OL has to.
My lords, so now interestingly, the OL also has been issued notice by the learned DRT, not once, not twice, but almost close to 8 to 9 times. My lords, they're simply not responding. My lords, I'm praying for that.
Your Lordship, basically their prayer has already been considered by your lordship while winding. Their prayer is that I, having accepted payment in respect of the winding up proceeding of Michael Fiber, which was the principal borrower. The winding up company was Tota Tingri. He now has come as a contributor of that Tota Tingri. He's a shareholder and therefore he has filed this application for keeping this proceeding in it. His contention is that Tota Tingri Tea Estate has filed an application before the DRT saying that we are discharged because we, the bank, have accepted,
The company petition.
we as a bank have accepted the payment that was gave out in that winding up of Michael Fiber. Your lordship, in paragraph 12-13,
Yes.
paragraph 11 onwards, if your lordship says,
So, Mr. Senapati, today.
I understand.
If possible, but let the OL put in a
Yes.
representation.
What is, why Madhya Pradesh? No, well, Michael Fiber is not in for this. Total. You can,
Appearance. Give your appearance. After hearing the learned counsel. If it for since there is a here, if finding as
What's the tariff? Why, for the Honorable Madhya Pradesh,
no.
here the record won't be.
Michael Fiber is
Madhya
for
Pradesh,
this honorable court.
I'll file an.
Party. Take steps.
Hello.
The OL. Take steps.
Careful, madam.